the legislative branch. The Kentucky General Assembly of the late 19th century, like the legislatures of many states, had lost much of the prestige and public trust it had enjoyed during the early years of statehood. In comparison with preceding Kentucky constitutions, and particularly those of 1792 and 1799, the document drafted in 1890 to 1891 reflects this loss of public favor in its extensive treatment of the composition, organization, procedures, and powers of the legislative branch of state government. According to the 1890 to 1891 Constitutional Convention's Committee on Address, the General Assembly of 1889 to 90 sat 149 days and passed local laws, including index, covering 4,893 pages. The convention responded in kind by proposing a constitution of 263 sections, approximately 140 of which directly named the General Assembly, its chambers, or members. The legislative powers of Kentucky's government are vested in a bicameral, or two-chamber, legislature called the General Assembly, consisting of a House of Representatives and a Senate, in Section 29. Despite substantial debate on a proposal to reduce the size of both chambers of the General Assembly in the interest of economy, the 1890 to 1891 Constitutional Convention retained the number of members prescribed by the 1850 Constitution, 100 House members and 38 senators, in Sections 31 and 35. Kentucky's General Assembly has retained its bicameral form since 1792, as no proposals for a unicameral, or one-chamber, legislature were considered by the 1890 to 1891 Constitutional Convention or presented to Kentucky voters in subsequent years. The concept of a unicameral legislature was considered by the 1964 to 1966 Constitutional Revision Assembly, but it was the overwhelming sentiment of the Assembly members, and of the 1966 General Assembly as well, to preserve the bicameral form. The direct election of both Kentucky's House and Senate members has been prescribed by Kentucky's Constitution since 1799. The 1792 system of indirect election of senators by a popularly elected electoral college, and the filling of Senate vacancies by vote of the incumbent senators, was abandoned in 1799 amidst general dissatisfaction with the state Senate. In fact, eliminating a Senate altogether was considered, but not successfully pursued, prior to both the 1792 and 1799 conventions. The length of state legislators' terms has been the subject of unsuccessful constitutional revision efforts in Kentucky. The 1890 to 1891 Constitutional Convention considered both lengthening and shortening the terms of the members of the General Assembly, weighing the goal of providing more experienced legislators against assuring more frequent electorate review of the members' performances. The convention ultimately retained the 4-year senatorial and 2-year representative terms specified in the 1850 Constitution. Both the Constitution Review Commission of the 1950s and the Constitution Revision Assembly of 1964 to 1966 proposed 6-year terms for senators and 4-year terms for representatives, with approximately 1/3 of the Senate members and 1/2 of the House members to be elected every 2 years. Both bodies offered their proposals with the goal of providing Kentucky with more experienced legislators, and the Revision Assembly expressed the additional aim of establishing greater legislative continuity. The Special Commission on Constitutional Review, created in 1987, recommended no change in legislators' terms. In contrast to the 1850 and 1891 constitutions, those of 1792 and 1799 established a minimum and maximum, rather than a fixed number, of House and Senate members. Apparently in anticipation of increases in the population and number of qualified voters to be represented, the 1792 Constitution prescribed from 40 to 100 representatives, while Kentucky's second constitution required no fewer than 58 and no more than 100. In both early constitutions, the minimum number of senators, 11 in 1792 and 24 in 1799, was established, with the actual membership of the Senate to be increased in proportion to the number of representatives added to the House. The 1891 Constitution was the first of Kentucky's 4 constitutions to base legislative districts on population, as opposed to a state enumeration of qualified voters, and, to a greater extent than the preceding constitutions, it emphasizes equality of population over the representation of political subdivisions and territory. The use of population was apparently a response to the difficulty of accurately counting the number of qualified voters, since voters were not registered, compared to the availability of U.S. Census data. In contrast, the current constitution's compromised emphasis on the criterion of equality in district populations was the result of sometimes heated debate among the delegates. The 1890 to 1891 convention considered, but ultimately rejected, proposals to provide an alternative method of reapportioning legislative districts should the General Assembly continue to fail to redistrict the state at the interval specified in the state constitution. Those non-legislative officers or bodies proposed to perform this duty included a committee composed of the Governor, Attorney General, Secretary of State, Auditor of Public Accounts, and Commissioner of Agriculture, Labor and Statistics, or a Board of Apportionment composed of 5 persons appointed by the Governor or the judges of the Court of Appeals. The argument that reapportionment was properly a legislative function triumphed, however.
The issue of state legislative reapportionment, which generated such extensive debate in 1890 to 1891, continued to be a controversial subject in state legislative and judicial chambers after the Constitution was adopted and, more recently, has been an issue in federal courtrooms. The pre-1890 pattern of Kentucky's General Assembly failing to reapportion the state at the required intervals continued into the 20th century, although new reapportionment plans were developed in both the 1960s and 1970s. Between 1891 and 1955, the General Assembly passed only 5 of the 7 constitutionally prescribed redistricting laws, of which those of 1906 and 1930 were invalidated by the State Court of Appeals on constitutional grounds. Only those passed immediately after adoption of the Constitution, and in 1918 and 1930 became effective. The competing criteria for legislative districts debated by the 1890 to 1891 convention delegates of population versus political subdivisions and territory also extended into the current century. The Kentucky Court of Appeals, in invalidating the 1906 redistricting plan, held that the constitutional prohibition against joining more than 2 counties in a representative district was secondary to the equal population requirement. However, the prohibition against splitting counties and forming legislative districts continued to be followed in forming legislative districts through the 1963 Reapportionment Act. Partly as a result, substantial population inequalities continued to exist in the 1960s. For example, the largest Senate and House districts contained approximately twice the population of the smallest districts in their respective chambers. In 1971 and 1972, when the General Assembly again wrestled with the reapportionment issue, both the players and the rules of the game had changed. In 1962, the United States Supreme Court had ruled that the Equal Protection Clause of the federal Constitution and federal court jurisdiction extended to state legislative reapportionment controversies. In subsequent decisions during the 1960s, the court had established and elaborated on the supremacy of the one-person, one-vote standard over other considerations in forming state legislative districts. Based on these decisions, in 1971, a U.S. District Court declared Kentucky legislative districts to be malapportioned and further ruled that those provisions of the Kentucky Constitution Section 33 prohibiting the division of counties violated the 14th Amendment to the U.S. Constitution. A 1971 Extraordinary Session Reapportionment Act was later declared unconstitutional because efforts to preserve county boundaries by splitting a few counties had resulted in violations of the one-man, one-vote standard. The 1972 General Assembly enacted redistricting plans that divided even more counties, in KRS 6.011 and 6.031. The findings of the 1980 and 1990 federal censuses resulted in further reapportionment of Kentucky's legislative districts. The Kentucky Supreme Court in 1994 held the 1991 Reappointment Act invalid on the basis that Section 33 mandates the division of the fewest number of counties while using the least variation in population. The court, however, delayed the application of its decision until January 1995, after the 1994 legislative elections. In 2012, the Kentucky Supreme Court held the 2012 redistricting legislation unconstitutional, based upon Section 33. The Kentucky General Assembly is responsible for legislative reapportionment. In some other states, by constitution, statute, or court decision, the most recent reapportionment of state legislative districts has been completed by non-legislative officers or bodies, including state and federal courts. Constitutional revision efforts of the 1950s and of 1964 to 1966 both retained the concept of reapportionment as a legislative function, but each proposed creating an advisory body to prepare reapportionment plans to be submitted to the General Assembly.
Historical background of legislative procedure. Although somewhat more restrictive than those of Kentucky's Third Constitution, the provisions of the 1891 Constitution governing the contents of laws and the procedures by which they are enacted are similar to those of prior Kentucky constitutions and constitutions of other states. Procedural and legal form requirements added in 1891 included the provisions for an enacting clause, for setting forth amended laws at length, and for enrollment of bills, and for the presiding officer's signatures on bills. The 1891 Constitution was Kentucky's first to allow the governor to exercise the line-item veto on appropriation measures. The 1850 Constitution did not specify that bills vetoed after legislative adjournment were defeated, probably because there was no absolute limit on the length of the General Assembly's biennial sessions. The principal procedural and organizational changes in 1891 were those concerning the organization of the legislative branch and, in particular, the length of its regular sessions. The delegates to the 1890 to 1891 Constitutional Convention said that the people of Kentucky felt that they were burdened by special legislation, laws written to apply only to specific individuals or localities. The special and local laws passed by recent legislative sessions were frequently criticized during the convention proceedings and constituted the first item mentioned by the convention address transmitting the proposed new constitution to the voters. Because of the volume of special and local legislation, the General Assembly sessions prior to 1891 had been extended well beyond the basic 60 days prescribed in 1859, under the legislature's authority to do so by two-thirds vote of each chamber. The 1889 to 1890 General Assembly reportedly lasted 149 days, with cost to the state in printing of $17,223.65, and in other respects $151,014.82. In the interests of economy and the reduction of the number of state laws, the 1890 to 1891 convention proposed to curtail the flow of special and local laws. Having done so, the delegates concluded that there was no longer any need for the General Assembly to be able to extend its biennial 60-day sessions, and that the authority of the governor to call extraordinary sessions should suffice in the event of an emergency. A second change in the organization of the legislative branch adopted in 1891 was the limit on the number of employees that each chamber of the General Assembly might employ. Todd County Delegate H.G. Petrie, in proposing current Constitution Section 249 to the convention, characterized the legislative method of hiring clerks, doorkeepers, and other such officers as a burden to General Assembly members. In favor of a constitutional limit, he argued,
"When this convention has fixed the number, they will be employed without the trouble of log rolling for these minor positions, and they will save at least $10,000 or $15,000 a year. Do the economists say that is a trivial matter, not to be considered at all? If we are entering upon a system of economy, why not start right here? Here is a place where we can cut off and do no harm, and here we can save the members of the General Assembly from very unpleasant annoyance."
Thank you for viewing this history of the Kentucky Constitution. For more information, please see the following references. Citizen's Guide to the Kentucky Constitution by the Legislative Research Commission, available online. Or the book, The Kentucky State Constitution, by Robert M. Ireland, Oxford University Press.